Okay, we'll just wait for the last few people to come in and then we'll start the session. So if you could come in and find your seats as quickly as possible. Okay, so I think we're mostly back, so we're going to start this session. I hope you all had a good lunch and a good bit of networking and discussion of some of the issues from this morning. We're now moving into our first working session 1, which is titled Towards a Shared Understanding on Internet Freedom Online Content. I think a number of the big issues that are going to come up under this heading, as you'll see from the introductory paragraph there, quite a few of those were touched on already to some degree this morning. So I think this session gives us a chance to really explore these issues in some greater depth with a very interesting and mixed panel of experts. So I'm not going to take too long to introduce the session because I want to get straight on to our speakers. But let me just highlight some of the issues that I think I would like to see us debating in the next 2.5 hours. And before I go any further, though, I should just remind everybody that the hashtag is for the Twitter feed is DCIF, if I've got that right, and the Twitter handle is @NetFreedom2012. So as in the previous session, we'll be taking more questions from the live streaming as well as from the audience here in the hall. We're also, you may be glad to know, we're going to have a short tea and coffee break just about by 3:30 for 15 minutes. It's quite a short one, so when we get there, can I ask you to go out, have your coffee and tea, and come back quite promptly, not least as we're also finishing the session 15 minutes earlier than it says on the programme to enable us all to get to the Google Big Tent event on time. So this session will finish promptly at 4:45. And we're also going to adopt a very slightly different format to this morning in the sense that we're going to ask each of our panelists here to give an introductory presentation of about 5 minutes to set the stage for some of the big issues that we're going to debate, and then it will be a purely interactive event, and we'll have a very short summing up at the end. So going back to the issues of this particular session, I think some of the issues in terms of online content were obviously concerned, given the emphasis this morning of freedom of expression, of respecting international human rights on the net as much as off, issues around direct censorship and the different ways and the different actors that are involved in direct censorship, I think, are of particular concern here. The use and the increased use of blocking, of filters and various ways of filtering, and we've seen that both in authoritarian, totalitarian countries, but we're also seeing it in democracies and quasi-democracies, if you like. So I think unpacking some of those issues a lot. Also looking in particular at the role of private companies. Is there to some extent privatization of censorship going on, and what should we do about that? Frank La Rue talked this morning about states should not delegate their responsibilities. Can we talk that through some more in this session? What about the big increase in a number of countries in the number of takedown requests and the range of issues and reasons for takedown requests? A takedown request from governments, companies, individuals really related to laws and real problems, or are they an attack on critics and freedom of speech? And how do we tackle that? Do we tackle that by strengthening understanding and the use of oversight, the use of court orders? Do we tackle it with greater transparency? And once we're into privatization of censorship, takedown, transparency, then the issues around intermediary liability come to the fore as well. Last but not least, and this was touched on to some extent this morning, the whole issues around intellectual property right, the arguments around and debates around copyright. We did touch on ACTA already this morning. I think those again we'll explore more in this session. So as you can see, we've got a lot to get through and I think a lot to keep us busy, and we won't all agree on all of this, so I hope we can have a very lively and open session, respecting the differences of view but being completely frank about our own positions or questions, or also frank about where we think it's unclear and a lot more work is is needed. The one thing we won't mostly be talking about in this session, I should just say, are the crucial issues around surveillance and privacy, because they're going to tend to come up in tomorrow morning's session. So I certainly don't want us to preempt tomorrow morning's session. Okay, well, with no further ado, let me just briefly introduce our 5 panelists, and then I will hand over to them, and then we'll have the debate. So to my immediate right, I'm very happy to welcome Professor Michael O'Flaherty. He is the Chief Commissioner of the Northern Ireland Human Rights Commission, and he's also Vice Chair of the UN Human Rights Committee, and he's Professor of Applied Human Rights and Co-Chair at the University of Nottingham Human Rights Law Centre. So I think he's going to be an excellent person to lead off in this session, which is designed especially to focus on some of the international legal issues around internet freedom. Then to his right is Helen Sheehy, who's Solicitor and Head of Legal Affairs for the Irish Recorded Music Industry, and she's going to particularly focus in her remarks on some of the issues around copyright and the particular experience and knowledge she has of the Irish situation. Then to my immediate left is Mr. Cory Doctorow, who's a novelist, a science fiction author, activist, journalist and blogger. He's a co-editor of Boing Boing and author of Little Brother. And he also said to me, although it's not down here just before we started, that he's also a publisher, so that his views on copyright come from both being a publisher in some sense as well as a writer. To his left is my colleague from the Free Word Centre back in London, Dr. Agnes Callamard, who's the Executive Director of Article 19, a very well-known and leading international freedom of expression organisation. So welcome, Agnes. And last but not least, on her left is Emin Milley. We spoke on a panel exactly a week ago at the House of Commons in London on Azerbaijan and the attacks on freedom of expression there. He's a blogger, a student, an intellectual, and I look forward very much to hearing his comments too. So I'm going to start by asking Michael to go first, and he's going to use his 5 minutes, as I say, to talk about some of the issues in terms of international human rights law and whether or not that needs amending into these internet days. Michael.
Thank you very much, Kirsty, and good afternoon. It's a great pleasure to be here. And by way of starting off, I'd like to react and impressionistically react to the discussion this morning in a way that I think is relevant to our topic this afternoon. And the first impressionistic response to this morning is a reminder that it's important that we don't exaggerate the novelty of the issues we're facing, the discussions we're confronting around matters of regulation of the internet. Every time we've had a new medium, we've had similar discussions. And this was brought home to me by looking back over the MacBride report from 1980. That's the report that set out the need for the world to have a global free communication space, one that was founded on human rights, which would deliver for human rights, and which itself needed human rights, particularly freedom of expression, in order to thrive. They're messages from 1980, directly relevant to our discussions in 2012. And the second observation from this morning has to do with the tendency every time we have a new medium for states to impose new regulatory frameworks. If you look back through history, Frank LaRue spoke about the book this morning. The first books that were published were kept in cages, including to limit access to the books. That is, in a sense, a regulatory framework. I did some research recently around attempts at control of the wireless after the Second World War, where countries such as the United States and the United Kingdom were calling for a very strict regulatory framework that we wouldn't find acceptable today. And so that's a reminder that calls for regulation at the time of emergence of a new medium have to be dealt with extraordinary caution. We'll look back in 20 years otherwise and be appalled at what we allowed to happen. So then, the question has to be asked at the outset today of whether the international framework that we have, the human rights framework that we heard so much about this morning, is fit for purpose. And it'll come as no surprise to you to hear from me that I think that it is sturdy and well capable of providing the protective space for the internet, as well as the fundamentals for any regulatory framework. The capacity of international human rights to deliver in this sector has been brought home very strongly by a very recent initiative of the body on which I serve, the United Nations Human Rights Committee. a few months back, and I was the principal drafter for the exercise, we adopted what's called a general comment on Article 19, the freedom of expression provision in the International Covenant on Civil and Political Rights. And this general comment is a broad analytical document that sets out the application of the law, and in this case on issues of freedom of expression, where we made a number of points of direct relevance to the discussions here in Dublin. The first of those is the reaffirmation explicitly for the first time that international freedom of expression standards embrace the internet. The internet is not something special and different that needs different treatment. Article 19 and all of the other relevant human rights provisions directly apply to, speak to, and give guidance with regard to the operation of the internet. Secondly, in terms of the breadth of freedom of expression under international law, we made clear for the first time explicitly in a document of this sort that Article 19 embraces a right of access to information held by the state. And again, this is directly relevant to a lot of our discussions. The general comment has most to say about when a state may regulate the internet, may interfere with the right of freedom of expression. And again, there's extensive commentary around the steps that the state must go through if its regulation of the internet is to be seen as legitimate as a matter of international law. None of this is new, but it's laid out with a level of detail that's important with regard to such issues as the principle of legality. We can't have the internet regulated by mere administrative diktat, such as with regard to the internet restriction only being permitted for certain designated, identified reasons, and the definitions of those reasons have been tightened up. So if a state restricts on the basis of morality, the general comment makes clear that not any form of I think it's right or wrong will apply here. It must be a sense of morality compatible with the universal protection of human rights. And since time is short, just one other example of the limits on restriction by the state of expression on the internet has to do with the nexus between the declared harm, or the harm the state says will be caused by the expression, and the particular act of expression itself. We can't have some vague, generalized sense that a sector is dangerous. That would never be enough to legitimize a restriction. So that's the general comment, the main point I wish to draw attention to in my brief presentation. Let me wrap up by some suggestions as to how we might work with Article 19, the provision, how we might work with the general comment and make sure that its analysis of Article 19 and of freedom of expression is carried through in the internet sector. Firstly, states. It's very important that states measure their own behaviour, their own engagement around the issues in relationship to the level of detail laid out in the general comment, and that they use it as they critique each other. I forget who, but somebody this morning, I think it was the Council of Europe Commissioner, spoke of the need for states to engage on this issue in, for example, the Universal Periodic Review System at the UN. They now have a tool that will make that much easier. Secondly, civil society. You have a crucial role in promoting awareness of this new extrapolation of the standards. And you also need to get us the information in the international monitoring bodies so that we can speak to these issues. The UN Human Rights Committee has not said much on the topic of the internet, not because it's not interested or engaged, but because civil society is not bringing the issues to it in order for it to react. Business, the commercial sector present here, an enormous role in promoting a sturdy awareness of this application of freedom of expression. I'd pick up on the point Frank LaRue made in his report last year around the extent to which those of you in the commercial sector need to pay attention to the Ruggie work, the work on human rights and business, to incorporate the so-called Ruggie framework into your forms of engagement. The small number of groups involved in the Global Network Initiative need to interpret their principles, those rather scant and undetailed principles. They need to be interpreted in light of the best practice understanding of what Article 19 of the Covenant actually says. And finally, there's one group that I'd like to mention. They haven't been mentioned yet today. I work in one of them, and so I wouldn't be doing my job if I didn't raise them, and that's national human rights institutions and their roles in promoting a proper internet freedom and an internet space. 64% of OSCE countries have a National Human Rights Commission. By the way, that's much too low. It should be 100. But to the extent that they exist in OSCE states, they need to engage around these issues. These bodies sit in a unique space between government on the one hand, civil society, and then business. And they can negotiate a relationship across those three actors in the sectors in a way I think that would be very useful in promoting a rights-based approach to internet governance and the protection of internet space. Thank you.
Excellent. Thank you very much, Michael. Let me just ask you one question. I'm sure we'll explore these in more detail once we've heard from the whole panel. But you mentioned the business role just then, and I think, and the Ruggie principles, but businesses have a natural tendency perhaps to err on the safe side. A government tells them to take something down or tell them it contravenes national law, and they may have a tendency to go along with that. So maybe some first thoughts on how that needs to be developed to ensure that businesses aren't either being asked too much to defend human rights beyond their capacity, but aren't giving in at the first go.
Sure. To my mind, the role of the international human rights regime with regard to business is twofold. In the first sense, it's about regulating their own behaviour in terms of promoting expression on the internet to the appropriate level. And then secondly, it provides them with tools and equipment in order to assess the demands of state. We heard this morning of how state is outsourcing its own function to the private sector. And I'm aware that some elements of the private sector are very worried about this and are engaging with it in a responsible and principled manner. The new international guidance emanating from this general comment and other guidance, such as the work of the various special rapporteurs, provides business with a framework, a rule book, a roadmap, if you will, through the various requests to determine which are legitimate, which are illegitimate. And certainly mere administrative requests that aren't strongly rooted in a legal framework that's subject to proper judicial review will always be unacceptable as a matter of international law.
Okay, excellent. I think that's very clear. We will pick up more on that in a little while, I'm sure. I'm going to go on straight now to Cory Doctorow. The floor is yours.
Thank you very much. So, since the WIPO Copyright Treaty discussion kicked off in 1995 and was passed in 1996, we have had a decade and a half of internet skirmishes that have gone pretty much nowhere on copyright. Before the internet and the growth of the PC, copyright was something that was rarely invoked. Copyright assumed that if you were making a copy, you were doing something industrial. When you copied a film, you probably had a film plant. When you copied a record, you probably had a record press. And so it accordingly set a set of industrial regulations in place for people participating in the entertainment industry's activity. But we had inflation in copying thanks to computers. Something that used to happen rarely now happens millions of times a day without us noticing it. The people in this room collectively have made more copies today than the entire world had made up to the passage of the WIPO Copyright Treaty. And yet, we decided that since we were all copying, that copyright was the right place to regulate our activity. We have thus had a decade and a half of policies related to copyright in the internet that have extended copyright dramatically without making it any easier to enforce copyright or pay artists. High civil damages. We now have the spectacle that LimeWire, an American P2P company, owes the record industry more than the entire value of the solar system. Higher intermediary liability with more stringent requirements so that anyone who allows the public to post onto the internet is now expected to review all of the material before it goes live. YouTube alone, just one of these services, is now receiving 72 hours of video every minute, 3 days of video a minute. There aren't enough lawyer hours remaining between now and the heat death of the universe to review all of that material. Criminal penalties for copyright infringement. Children who listen to music the wrong way can go to jail. Extended and unsupervised surveillance powers of the internet. Subsidies on enforcement with very little oversight. So websites like DeJazz1, which was an American hip-hop website that received hip-hop music from hip-hop labels and posted it, had their domain disappear for an entire year. Until the Department of Justice finally realized that they'd been acting on a bad tip from the record industry and gave it back and refused to say any more. And then, of course, national firewalls that are blocking websites without any kind of oversight, without any necessity to prove that any wrongdoing was taking place, and without any proportionality test. Websites that may host millions of infringing works, but also millions of non-infringing works unavailable to the citizenry of countries. And yet the amount of copying hasn't gone down. All of those measures, 15 years later, the amount of copying has only gone up. The amount of copying will only go up. This day, 2012, this is the hardest copying will ever be from now on. Your great-grandchildren will marvel at how hard it was to copy in 2012. You'll sit around the Christmas table and they'll say, tell me again about in 2012 when you couldn't buy a half dozen hard drives in a blister pack for €1 at the checkout desk at the chemist that could hold all the music ever recorded, every movie ever made, every word ever spoken, every photo ever taken. There is nothing we can do to make copying harder. That can't be copyright's purpose. When we try, we end up doing terrible violence to the internet. And the internet, after all, is not just a way to be entertained. Martha Lane Fox, who's the British champion for digital inclusion, commissioned a PricewaterhouseCoopers study of how access to the internet affects the poorest and most vulnerable people in Britain. And what she found is that when you compare like-for-like households, both living in housing estates in the post-industrial north of England, except one has the internet and the other one doesn't, that the family with internet access has better nutrition, their parents have better jobs, the children have better access to education and more social mobility, they are better informed on civic matters, they're more engaged in politics. In every measure of what we think of as positive social policy, the internet delivers. And yet we are poised in the UK and all over the world to take away the internet from people who live with people who are accused without proof of downloading music or movies. That is so vastly disproportionate that it beggars imagination. We heard this morning about the internet's role in the Arab Spring, and we've heard many stories of how the internet changes people's lives. There is no way for us to increase the liability borne by intermediaries without impacting all of those things. There is no way to create systems of unaccountable censorship and surveillance without surveilling and censoring all the things that we do on the internet. There is no way to create digital rights management systems that design our devices so that they watch what we do and intervene when we ask them to do things if they've been told we shouldn't be allowed to, without designing devices for the police state. Copyright should be designed to pay artists. We can imagine things like the blanket license that a radio station has being offered to an internet service provider so that money could be directly transferred from people who love music to people who make music. That's a proven, non-speculative solution, collecting money for music and giving it to people who make it, as opposed to extending copyright or adding surveillance and censorship. Moreover, we need to align the arts with free expression. It is revolting to see artists arguing for censorship. I say that as someone who makes his living from copyright and feeds his family from copyright. Artists should always be on the side of a free society and always opposed to all forms of censorship, period. Since everything we do today involves the internet and everything we do tomorrow will require the internet, we must regulate the internet with the gravitas that it demands. There is no such thing as copyright policy if we say that everything involving a copy is under copyright. It just becomes internet policy, because everything we do on the internet involves copying. And there's really no such thing as internet policy anymore. There's just policy. My colleague earlier said that he thought that the internet didn't require new and special regulation. I think he's right, but I think it requires new and special regulatory consideration. Because after all, it is a new kind of medium. It's a medium that in one wire delivers freedom of speech, freedom of expression, freedom of the press, freedom of assembly, access to education, nutrition, social mobility, political awareness, and civic engagement. And we should regulate it with the light touch and consideration that it deserves, and not as a mere glorified system for listening to music or watching movies. Thank you.
Thank you very much, Corey. And
You're welcome.
just one question. You already talked about there being other ways of ensuring that money can still be gathered and given to artists. Can you just say a little bit more about that? I'm sure we'll come back to this in the discussion.
There's loads of ways that you can imagine it, and they're all distinct to different industries because different kinds of creativity have different requirements for how they're funded. But in the case of music, we've solved this problem repeatedly. When the first recorded music came along, the people who wrote music thought it was a form of theft. John Philip Sousa, the great American composer, said that if these infernal talking machines are allowed to continue, we will lose our voice boxes as we lost our tails when we came down out of the trees. Right? You know, many points to Sousa for being an early advocate of the theory of evolution, but he kind of missed the big picture there. The way that we sorted that out is we created a blanket license. We collected money from people, or a compulsory license. We required people who made music, sheet music, to sell the right to record music to people who recorded music. We collected money and we gave it to artists. When radio came along, the people who'd made records viewed radio as a form of piracy. You know, every pirate wants to be an admiral. They think the innovation they did was legitimate. The innovation that's disrupting them is terrible. So the record companies thought radio should be illegal, and the radio stations advocated for blanket licenses, and they eventually got them, and blanket license music came on the radio. If ISPs were offered, say, a €5 a month blanket license for all the music, downloaded however you want, sampled using the same kind of statistical sampling that we use for other kinds of blanket licenses that they could opt into, and if, as a statute, we said half of that money, regardless of the contract that the artist has with their label, must go directly to artists, we would the next day begin to take money from people who love music and give it to people who make music. It wouldn't take forever. It would happen immediately, and it would be lots of music. I mean, €5 a month from everybody who loves music on the internet is a titanic sum of money.
Okay, excellent. A lot to come back there, but first I'm going to go on to Agnes Callamard, who's going to talk to us about some of these issues from Article 19 point of view.
Thank you very much. I would like to maybe highlight what I think are some of the paradoxes with the issue we are trying to tackle today, and point to you a couple of such paradoxes for greater discussion afterwards. The first paradox, I think, is around the legal framework regarding internet and the role of human rights in that context. On one hand, I think human rights organizations like Article 19 have witnessed over the last decade, or at least the last 5 years, a very large number of government-driven legal intervention, particularly in the form of laws, whether they are connected to internet directly, laws on internet, data collection, cyber security laws. We've just heard about copyright, IP, and so on. So I think it is fair to say that as a domain of human interaction, of economic development, of political expression, the internet appears to be heavily legalized at some level. And yet the paradox is that in many ways it's still not heavily legalized. And indeed, maybe one can argue that the internet is at the forefront of a legal transformation of the way national governments and the international community are going to look at their legal responsibilities. And what we are somehow witnessing is a shift of emphasis from laws created and enforced by state-connected institutions to a greater focus on private governance mechanisms and private legal regimes. There is a growing body with regard to internet of national, regional, and international rules and institutions which are increasingly private-public, or indeed solely private. And I think it is a paradox which we are tackling, which we are looking at. We have not necessarily, at least not at Article 19, highlighted or determined what does it mean for the area and for internet in particular, but it is, I think, something that is quite striking. Another paradox, which is related to the previous one, of course, is that of governance of internet. And I will not spend a lot of time on that topic, but I think we also need to be aware of the fact that on one hand, We, human rights activists, internet freedom, many governments, a number of them private sectors, are pointing to the necessity of a multi-stakeholder approach to internet governance, and I think that is right, for a variety of reasons linked to who uses it, who produces for it, and so on and so forth. Where does it come from? What does it offer? So there is this, this principle of multi-stakeholders approach, which is hammered every time, which we hammer every time we have the opportunity. Yet the paradox is that in many ways, actually, it is almost just a front, because when you look at who really govern internet, as our colleagues from India are keen to point out, it is not multi-stakeholders. It is ICANN, and we know where that is. It is the largest companies, and we know where they are. So there is, and I'm not saying that it is wrong, or that I'm just saying it is a paradox. And there are many sacred cows in internet freedom, and the way we tackle it, which I think at some point we will have to more forcefully confront them and try to see whether or not there are sacred cows that needs to be made sacred, or whether we need to move forward and try to go beyond it. The governance questions and the multi-stakeholders issues is particularly topical at the moment, because as some of you may know, there has been some quotation marks suspicious proposals for ITU to take a greater role with regard to internet governance. And we find them to be suspicious mostly because of where they come from, not necessarily because of what they are proposing, which is also another a paradox of the world we inhabit when it comes to internet. Still, I've been asked to talk about a different kind of paradox, which is that linked to the role of the private actors and how they are taking a greater role in internet matters, whether they like it or not. And I suspect quite a few don't, but a few may as well. The notion of rule of law, when it is applied to internet, becomes a very fuzzy one. It is the extension of the paradox I had mentioned earlier, where you have a heavily legalized sector with very strange-looking enforcers, not the usual one. And in the case of internet, most of the enforcers happen to be the private sectors, or what has been called the ISP, including the platform providers, not just the technology providers. So what is the situation? We have a situation where, for reasons mostly linked to the fact that under the law, in many countries of the world, not the United States, I will say, most countries in the world have made those providers liable for the content that is being produced on their technology or through their technology. In many ways, this liability is pushing those actors to take very strong preemptive, or not so much preemptive, but is pushing them to take actions when it comes to some quotation mark against suspicious content that has been the object of some complaints or allegations. Many service providers, and to a lesser extent platform providers, will, in response to those requests for takedown, will actually act on that request very quickly without necessarily due consideration for the actual content that is being at stake. For freedom of expression activists and internet freedom activists, that approach is particularly problematic. There has been a number of tests being made around the world where we've actually found that in the vast majority of cases, the takedown, the product that was taken down, was actually not meeting any kind of test for that will match the restricted, the legal restriction for freedom of expression. Sorry. So the question of intermediary liability is particularly crucial for us. It is linked to the ability of the users but also of other actors to regulate what is being online, and it is questioning the emphasis placed by governments on that particular actor to do a regulation that many of us think should be done by actors that are related to the state. On the other hand, governments have argued that there is so much content online that, of course, they can't be asked to be regulated and so on, and that the ISP, through their various mechanisms, are better placed to regulate the content. At a practical level, there is something that can be indeed argued along those lines. At a principle level, of course, I'm returning to the earlier paradox about the transformation of the way the state is enforcing its own laws and whether this is the way we want to go. Most of these, the content online, according to international human rights law, should be subjected to the same principle and certainly the same system than content offline. And by attributing to ISP and platform providers a role of that is nothing short but of a censor, the government is actually failing in its obligations and in its respect for freedom of expression. That will stop here.
Okay, excellent, thank you. Just one quick follow-up question. It's something that I think hasn't been mentioned yet today, but the whole question of mobile technology. A lot of the mobile telecom companies are putting filters on way ahead of some of the debates we're having here about whether there should or shouldn't be filters or when there should be filters. You know, I mean, it's a big topic, but is there a brief first remark on that? No? Anybody else on mobiles? Well, we'll throw it out to the audience later in that case. I think it is quite a big issue here in terms of the censorship on mobiles and apps is actually ahead of what we're seeing on the internet, and we're still debating on the internet. But before we do that, Emin.
Thank you very much. From what speakers talked about, I could see that actually this online content and issues some of us concerned with, which are, some issues are more relevant in certain countries and less relevant in other countries. There are a lot of questions, and when we're talking about online content, I'm also thinking that the online content is very much basically, created often offline and then put online. And we are living in the age where it's not just people like me who are empowered by internet, but it's also certain governments who are using internet in an unlimited way, violating its own laws, the ethics, and doing it covertly. So how to hold these governments accountable, how to deal with certain private companies, which you mentioned that there should be some self-regulation on the way how companies behave online and so on. But I want to just bring, we don't have much time and I don't want to take much of your time, but I want to bring in the case of Khadija Ismailova, I think the bravest journalist in Azerbaijan. And I think her case, in a way, connects all these different issues in one very concrete case of a life story of one person. So Khadija Ismailova, she was investigating a president's family business. And she came up with very professional, well-founded, grounded reports about it. And when she was doing it, she faced something very outrageous. They started to blackmail her. They planted a camera in her bedroom and told her that if she will not stop it, it will be online. So you are in this situation, and Khadija, unlike her other colleagues, and also male colleagues, didn't stop. She went public about it. She didn't stop the investigation of president's family businesses and actually published a couple of more reports. So she had to pay the price. she lodged a complaint to prosecutor's office, which was ignored for 1 week. The newspaper, official newspaper of the ruling party, published an article about her lax morals, making hints, helping basically people to go on this website and find more about the story. And all this was put online in the same night, and it was available online. When Khadija actually, then the backlash in society was amazing. I think calculation of people who did it, and according to Khadija, she suspects very much people in presidential administration who did it, and all evidence, points out in that direction, because what happened is, in her case, the calculation was not just blackmailing; it was about basically provocation for assassination. Azerbaijan is a socially conservative country, and she's an unmarried woman having free sex, and someone is filming this and blackmailing her and trying to stop her to do her investigations, and then putting this online. Okay, now we are coming from offline to online. We have a case where most of activists in Azerbaijan and Khadija herself basically, and after actually she invited a person from state telephone company to say, who put these wires here, like, do you know how? And the guy said, it's me, I did it. She said, how you did it? He said, well, my boss asked me and I did it. And the guy from prosecutor's office, who was then, by then the government condemned when they have started to see the backlash in society, so there was official investigation. The guy from prosecutor's office just, tore apart the protocol. He refused to put it in a protocol, So this is the situation we are dealing with. And the most interesting part of the story, this is where offline also comes in. The people who did it in government, they badly miscalculated, because even the most conservative religious groups in Azerbaijan made statements in support of Khadija. And everyone in Azerbaijan knows that Khadija is outspoken atheist. And Azerbaijan is increasingly religious society. So you had actually a very touching story where actually religious lines, political lines, across the whole society, even in government itself, people who work for government, offline, online, everyone was outraged by this fact. So we moved on and tried to see who put this online, because there should be some, company who owns this hosting, And we found out that it's a company based in Texas. And some of our friends called the company, wrote them emails, and asked to take this down, explain them, what's going on. And the owner of the company was a 19-year-old guy. And he said, I'm not taking it down. So the problem is, of course, there is now some lawyers, pro bono lawyers in the US who are dealing with this case. But the problem is, this video is still there. So that's why it is really, I don't think it's just a problem. Of course, certain countries want to use this sort of pretext and, bring internet under certain of, I would say, over-regulation and making it really political and basically hijacking internet. This is agenda of some countries, and I think the upcoming Internet Governance Forum, which will take, by the way, in Azerbaijan in November, and the Telecommunication Union's event in Dubai in December, are the events to watch, because there are a lot of, global lobbying and advocacy work going on now. And certain countries are coming up with a list of things which they want to see regulated, and it's obviously not out of good intentions. They really want to get internet under control and restrict the freedom of internet we have right now. But on the other hand, we should also, I think about how to deal with these cases, because internet freedom has also this side, and maybe we can discuss it here. And I hope that during Internet Governance Forum, the case of Khadija will be on the focus because a small country like Azerbaijan never gets international attention usually. We get it when Eurovision is hosted in Azerbaijan and government spends hundreds of millions of dollars for this, but then a tiny small civil society tries to draw attention to human rights violations. And I hope the same can happen with Internet Governance Forum, taking the case of Khadija and really thinking, you know, how much we want to regulate and how much regulation is maybe too much and not in the interest of freedom of internet.
Excellent. Thank you very much. I mean, I think it's really, really helpful to get these very real and shocking examples. They bring to life what it's all about when we do discuss whether we need additional laws or additional regulations. And as you say, we are going to see increasing wish lists, and I think that's why debates and conferences like ours here today is really important. If you wait with your questions, because we have one more panel speaker, and then we will certainly open it up to debate. So last but by no means least, I'm going over to Helen Sheehy, and she's, as I said, from the Irish recorded music industry, and she will give us another perspective on the copyright debate.
Thank you, Kirsty. I represent the Irish recorded music industry, but I suppose for the purposes of today's discussion, since I am somewhat a lone voice, I speak for copyright holders. You could say that I represent the interests of artists, both visual and performing, writers, publishers, composers, producers of music and film. My people are the creators of art, of whimsy, of magic, and even joy. They are the ones that can call into existence something that never existed before. Exquisite creations, appalling creations, and every now and then something perfect. Their works are not all good, and they certainly are not all to everyone's taste. But they always provide colour and interest, and without them the world would be a very boring place. I know from my position within the music industry that a generation has grown up believing that music is and should be free. The music industry was merely the first, however. The belief is now prevalent that books and films, and indeed any product of creative endeavour that is digitized and transmissible via the internet should be free. And they are prepared to campaign to protect their freedoms. They campaign not in the traditional way, however. They use the internet to campaign. So from the privacy and anonymity of their own computers, they send out messages to politicians, and politicians take note, because that is the nature of democracy. I have watched, astounded at the way that the debate has polarized. Now, those that want to, and believe they have a right to, get stuff for free on the internet have become aligned with proponents of free speech and freedom of expression. Before I go any further, let me say that the people that I represent are totally and completely supportive of the right to freedom of opinion and of expression. Creation relies upon freedom of expression. Indeed, the concept of freedom of expression is the very cornerstone of copyright. But what is at risk for my people is their right to own property, their right not to be arbitrarily deprived of their property, their right to work, and their right to just and favourable remuneration for their work. Internet piracy has devastated the Irish recorded music industry. In the High Court case that the Irish recorded music industry took against the internet service provider UPC, Mr. Justice Peter Charlton found that between 2005 and 2009, the recording companies experienced a reduction of 40% in the Irish market for the legal sale of recorded music. This is equivalent to 64 million in sales, and went on to say that some 675 people are likely to be engaged in some form of illegal downloading from time to time, and that at least 20 million in lost sales are being caused to the Irish market by illegal downloads on an annual basis. Of course, when music is downloaded illegally, composers, performers, retailers participating in the legitimate music distribution chain, even the revenue commissioners, do not get paid. In the UPC case, Mr. Justice Charlton recognised that losses were being sustained by far more than the record companies who brought the case. He said, "I am satisfied that the business of the recording companies is being devastated by internet piracy. This not only undermines their business, but ruins the ability of a generation of creative people in Ireland and elsewhere to establish a viable living. It is destructive of an important native industry." Different freedoms can coexist, and recognition of intellectual property rights on the internet does not have to conflict with freedom of expression. What is required is a balancing of the rights. It is not enough to say that you support the rights of creators to get paid. It is not enough to say that you do not condone internet piracy. And please do not say that the music industry and presumably all other creative industries must find another business model, because the fact is no business model can compete with free. If you want to support creators' rights to work and to the ownership of their property, then you must support credible and effective methods of fighting internet piracy. Do not say it is an arms race, because if this could ever be a good reason not to fight illegality, then we might as well go home now. Neither the right to freedom of expression nor the right to protection of intellectual property is an absolute right. They must be balanced against each other and against other fundamental rights. Where fundamental rights are in conflict, a judgment must be made as to the comparative importance of the rights and the extent of the impact on each. The justifications for interfering with each right must be taken into account. The result must be proportionate. Website blocking that limits access to sites dedicated to infringement is critical for the protection of the fundamental right to property and to work, as well as to protect the freedom of expression of the creator. Such an order does not block the expression of views, but rather the illegal distribution of copyright material. As part of the overall solution, education is vitally important. We need to catch children in primary school and encourage them to develop their own artistic talents, whilst explaining to them that their intellectual property belongs to them and that they should respect the intellectual property of others. I'm going to finish by reading from the Artists' Charter, which was launched at the recent Hot Press Music Show. We, the undersigned, writers, artists and musicians, along with our fans and those millions of people worldwide who work in or are otherwise supported by the creative industry, say as follows. We have the right to earn a living from our work. We reiterate that basic human right to work, enshrined in Article 23.1 of the UN Declaration of Human Rights, and by virtue of Article 23.3 of that declaration, to just and favourable remuneration for our artistic endeavours. We seek to make technology a friend and not an enemy of our creativity. We ask to be allowed to make a living, whether through performing, writing or recording music, derived from the power of our ideas and the commercial use of our talents. We say it is a fact that the protection of our creative output depends substantially on copyright law, and we urgently call on all governments to assist us in the legal protection of our collective artistic output from piracy and other unauthorised infringement. It is self-evident that any commercial enterprise requires revenue flows to not only survive but thrive, innovate and take calculated risks. We say that the internet service provider industry must accept its share of responsibility for the rampant abuse of copyright online. Easy, unauthorised access to our copyright material goes unchecked every day across the world, and infringers do not seek our consent when sharing our works. Our creative industries are facing unsustainable revenue losses due to weak or unenforced copyright laws. This means one thing and one thing only: millions of jobs lost and young talent ignored. While our industry has collapsed to annual revenues of less than $20 billion, the ISP industry has more than doubled its revenues in the last 5 years to $250 billion, due in large part to infringement of our artistic works. We demand our indisputable right to copyright protection be no longer ignored. Free should not come at such a terrible cost. And it ends with, stand with us to ensure the creative industries survive. Well, that's what I have to say. Thank you.
Okay, thank you very much, Helen. One quick follow-up question which relates to something Corey said. You said there isn't an alternative business model where it's free, but given these changes, huge changes in technology, to what extent do you think we need to be looking at, even so, alternative business models? The technology also opens up extraordinary ways of much more individual connection with different users, for instance.
Corey suggested that perhaps we should take all the money from the music lovers and give all the money to the music makers. Well, that's a suggestion, but it would seem to me that if you did that, would you not just take all the music from the music lovers and give it to all creators of music equally? Good, bad and indifferent creators of music.
Yes, do. Yes.
No more than we do with any other blanket license. In fact, my sincere hope would be that a 21st century collecting society wouldn't be plagued by the problem that has visited every other collecting society, which is that mostly it gives it to the large record labels instead of independent artists. I would hope that we would actually distribute it fairly, maybe for the first time in Blanket Music Collection, because of course if there's one thing we understand in the 21st century, it's analytics of large heterogeneous pools of data, that is the business model of the 21st century.
Okay, I'm now going to open it up both to our audience here in the hall and to our internet audience. We've had an extraordinary range of issues here, so let me just remind you, we've covered the questions of, do the principles of international law in any sense need to change? Do they just go across directly? Are there paradoxes in that? What about the role of the private sector? They're ending up playing a much bigger role than we might want and than they might want, but what do we do about that? We've heard very substantial issues around governments deliberately misusing the internet, and we've heard the start of a fascinating discussion around the copyright challenge. So I'm going to take 2 or 3 questions at a time just to make sure we get as much debate as possible, and also encourage, I know there's a certain number of civil society representatives here, and it's always good to hear their voices too, but can you all keep your comments as brief as possible, say where you're from, and I'll start with the gentleman right at the front here, if the mic can come to the front, and then I'll go for the gentleman behind him, and then we'll take one more and come back to the panel.
So I'll introduce myself, Professor Alexander Borisov from Moscow, and I'm very much appreciative that after exchanging views among panelists, we have an opportunity to ask a couple of questions. I mean, rank and file, which is very democratic. Well, first, I'm rather envious of Azerbaijan. I cannot understand why it attracts so much attention. What's happening? Because of oil or bordering with Iran? I just don't know, because first session was devoted to some extent to Azerbaijan, and today we are discussing that. But that's not my message.
Well, I'm sorry, I need you to make a short comment or a short question, or I won't be able to get everybody in. So can you come to your key questions?
Thank
please?
you for reminding me that. My remark concerns a very important problem, which at least that's how we consider it in Russia, concerning copyright. I understand that 2 panelists stick to opposite views as regards copyright and piracy and all that. In the United States, there are 3 pillars regarding intellectual property and copyright law, entertainment law, and mass media law. For students of copyright
I'm sorry,
law.
I do have to ask you to put a short question. I
Are
cannot
you going to interrupt me
I'm
again
sorry,
and again?
I do need everybody to say within 1 minute.
You are going to ride roughshod, yeah?
I'm going to ask you to ask a short question so
Yes,
you can bring in a lot
question-
of people.
My question is that we do not understand in Russia this debate concerning copyright and information freedom, because I understand that copyright law protects private property. And what's the interconnection between protecting private property, intellectual rights, and freedom of expression and information? Because behind copyright, that was, by the way, the obstacle in the way of Russia joining International Trade Organization. So we very much interested in that. So behind copyright, a lot of laborers, so to say, intellectual laborers. And if we say, well, okay, we can steal that property due to the principles of freedom of information, how about that? So what's the interconnection and correlation between interests of many, many people, creators, intellectuals, and those who want to acquire and take it free of charge?
Okay, thank you very much. Could you give the mic direct to the gentleman behind you? Thank you.
Thank you very much. I'm from the delegation of the Russian Federation. My name is Alexei Vlasov. First of all, we would like to thank the Irish chairmanship for the excellent organization of this event, and as a delegation of a participating state, we would like to make also a short statement.
I'm really sorry, but within 1 minute we want to have an interactive debate, please.
I'm allowed to make a statement after the questions, or what is the procedure?
We're trying to have an interactive discussion, so if you could express your concern in a sentence and put a question, that would be very welcome.
And after that, will I be allowed to
no, because you're not on the panel, so we're not actually asking people to come out with longer statements. No,
it will not be long.
Yes, but that's fine. He can raise it within a minute, please. If you get on with...
Okay.
He asked me a question.
Can you maybe explain the procedure? Because we,
yes,
as a delegation of a participating state, we think, first of all, we should promote the dialogue between participating states, between delegations.
I will explain the procedure.
But not between panelists and
explain
NGOs.
the procedure since you asked me to. We've just had 5 interesting panelists. They all spoke for 5 minutes because I asked them not to speak for too long. They would have liked longer as well. We are now taking questions and very short comments. Questions and very short comments means anything under a minute. If you can do it in 30 seconds, even better. That way we get interactive discussion. That's the same for everybody participating in this conference. So if you could make your comment and with or without a question within 1 minute, that's the same rule I will apply absolutely equally to everybody in this hall. And there's a lot of people waiting, so if you could do that, that would be great.
Allow me to continue in Russian in this case.
Fine.
Интернет, создав новую среду для общения и взаимодействия людей, став общественной ареной нашего времени, оказал влияние и на понимание прав человека, включая традиционное право на получение информации и свободу выражения мнений. Возникли термины «новые цифровые средства массовой информации». И хотя почти каждый из элементов этой сложной системы имеет собственную нормативную базу, к ним в полной мере должно применяться международное право в области прав человека. Раздающиеся в последнее время призывы государствам принять новые обязательства по обеспечению и расширению свободы слова в интернете, либо экстраполировать на цифровые СМИ обязательства по традиционным средствам массовой информации не вполне корректны. В том числе потому, что институты и индивиды, составляющие интернет-сообщества, к примеру, администраторы и модераторы соцсетей и блогеры, не имеют юридически зафиксированных обязанностей перед государством, обществом и международным сообществом в целом. На поверку получается, что у государств только обязанности, а у интернет-активистов только права. Тема обязанностей граждан-авторов и других членов интернет-сообщества нуждается в углубленной проработке. Механическое придание блогерству и чатам статуса средств массовой информации влечет за собой выхолащивание профессиональной журналистики, поскольку размещаемые гражданскими журналистами сообщения далеко не всегда отвечают требованиям объективности и часто подвергаются критике за недостоверность информации. Важнейшее значение приобретают также вопросы ответственности работающих в новых СМИ журналистов перед обществом за предоставляемую информацию и, соответственно, журналистской этики. Уместным в складывающейся ситуации было бы требовать и от крупных интернет-компаний полноценно задействовать механизмы саморегулирования и самоцензуры. Применительно к свободе выражения мнений в международном праве отсутствует единое нормативное определение средств массовой информации, цифровых СМИ. С концептуальной точки зрения, в управлении интернетом, как наборе технических средств, должны учитываться не только права пользователей, но и интересы государств. В этом смысле Российская Федерация отстаивает принцип соблюдения суверенитета стран и правительств в отношении вопросов государственной политики в национальных сегментах интернета. Хотелось бы также отметить, что при обсуждении тематики свободы интернета необходимо иметь в виду такое основополагающее право человека, как неприкосновенность частной жизни. В последнее время участились случаи грубого вмешательства в личную жизнь человека, в частности путем перехвата электронной почты и отслеживания интернет-трафика под предлогом свободы интернета. Как известно, такие случаи получили широкое распространение как при прямом участии как государственных, так и негосударственных субъектов в отдельных странах ОБСЕ при использовании новых технологий.
Okay, could I ask you to stop
Особая
there, because you
озабоченность в
have
этой
now
связи
you have
вызывает
now had
создание...
over
Let me
two, you
finish.
no, you have had over 2
Особая
minutes, and I've
озабоченность в этой
asked
связи
you,
вызывает создание
we
глобальных
cannot
систем
run the discussion in this way, so if you
слежения и
could bring that
перехвата
to a
частной и
close.
коммерческой электронной переписки, таких как система
You
эшелон.
did ask me what the principles were for running this, and I asked you to stay within a minute. Could we now give the microphone to the young gentleman behind there, please? I think if you respect our panelists, you might respect the procedures we are using here, please. Could you find a microphone, please, and give the microphone to the young gentleman behind?
Why don't we have a tea break?
No, we're not going to have a tea break. I think we want to... Could I ask you to respect the rules we are operating here equally to everybody? Okay, well, I think we will stop taking questions from the floor, and we will at this point return to the panel. All right?
Take them from Twitter.
Well, we will take them from Twitter in a minute, but I think we'll return to the panel. Thank you very much for that. If you could give the microphone back, that would be appreciated. We are going to go back to the panel now. Thank you. If you could give the microphone to the young gentleman there, that would be appreciated. No, could you give the microphone back, because you're disrupting the meeting, and that's a bit sad, because we have some very important issues to discuss here. Well, you asked me the rules, I gave you the rules, and then you said you shouldn't have the rules applied to you. Could you give the mic to the usher, please? Please give the mic to the usher. You've made your point. Thank you very much. I am going to take the young gentleman back there. Yes, no, here, forward. But please respect the rules and stay within a minute, and then that will set a new model for the rest of the discussion.
Please use your headphone. У меня короткий комментарий. То есть анализ показывает, что проблемы с авторскими правами больше всего в тех странах, это, скорее всего, авторитарные и другие режимы, которые имеют проблемы как со свободой слова, так и со свободой конкуренции, также где чиновники пользуются большими привилегиями, конвертируют свою власть в бизнес. И я считаю, что нам нужно подумать, как развивать индустрию интернета. То есть саморегулирование, оно будет развиваться по степени, и борьба с нарушением авторских прав будет увеличиваться по степени развития обществ. А ограничиваться этими законодательными актами к никаким результатам нам фактически не приведет. То есть, опять-таки, посмотрите, где нарушается. В той же России, в которой представители пытаются поднять вопросы, почему обсуждается Азербайджан. В том же Азербайджане нарушаются авторские права. То есть, когда общество станет готово, там будет меньше нарушаться авторские права. Но бороться технически с нарушением авторских прав никогда не получится. Это то же самое, что бороться с распространением наркотиков во всем мире. Даже в самых странах, где борются с наркотрафикингом и распространение наркотиков, не дается никаких результатов. Но посмотрите на примере Голландии. То есть там общество поняло, и те, кто хотят пользоваться пиратским продуктом, они будут пользоваться всегда. А те, кто не хотят, они выбирают другой путь. Спасибо.
Okay, thank you very much. I'm going to come back first to Corey on the copyright issue, and then I will go to Emin, and then I will see if the rest of the panel would also like to comment on those issues.
So the situation that a new technology challenges copyright is not unusual, and it has nothing to do with property. When the first phonograms came along, the first means of recording music came along, the sheet music composers called them piracy. They were eventually legalized not by banning phonograms, nor by ensuring that you could only make a phonogram if you had permission from a composer, but by legislative intervention that said that the extremely popular new form of media should be legalized in the way that people enjoy using it. The same thing happened to radio, and radio came along, and the people who'd fought for and won the battle over sheet music, called the people who were doing radio, called the radio theft. They said, what we did was progress, what you're doing is theft. The radio went ahead by legislative fiat. Then cable came along, and the broadcasters said, well, when we took the records, that was progress, but when you take our signals and put them on cable, that's theft. And again, blanket licensing, regulatory intervention saved the day, and now we have legal cable television. And then the VCR came along, and the people who made cable television said, when we took the broadcast signals, that was theft. What we do here today is progress. And again, it was the Supreme Court in the United States in 1984 in the Betamax decision that legalized the VCR. At no time have we successfully imposed prohibition on new technology. Technology has winners and technology has losers, but expanding the reach of the media only benefits creators in the long term, and that's what we need today. Sui generis regulation that respects not just creators, but the need of all people to participate in global media. I think that's the right answer. I think it has nothing to do with theft. It has nothing to do with supposedly representing all artists, including writers, presumably including me. It has to do with realpolitik. It has to do with not creating a generation of criminals because you can't legalize technology.
Okay, I'm going to actually ask Michael to come in on this one and see where he sits on this copyright question amid this range of views.
Sure. And I also would like to respond specifically to Professor Borisov's question, because it seems to me, and Helen made the point earlier, that there are issues of human rights here. The copyright holders have human rights, and we have to engage with that. And it's not just property rights; it's also a right to a living, a classic socioeconomic right. So what we have to do is match that to freedom of expression, and balance these two rights, and come to a conclusion. That means we do need some form of regulatory framework that will do justice for copyright holders. I personally don't have a view on what that should look like. It's not my expertise. We've got two panelists here who've spoken from very different directions on that. What I would suggest, though, that the levels of disagreement and of charting our way blindfolded through new issues is such that this is certainly not the moment for any strong new regulatory framework. We're not ready. We don't understand the issues sufficiently yet. What is clear already, though, is that the penalties are often inappropriate. The closing down of intermediaries seems to me to violate the principle of proportionality under Article 19 of the International Covenant, and certainly the 3 strikes and you're out with regard to end users or any variant of that is exceptionally disproportionate. If we keep in mind what we heard earlier, that the internet is a vehicle for the enjoyment of the whole gamut of your human rights. And if you're excluded from that world, then that's an extraordinary penalty which would raise serious issues.
That's very helpful. Helen, could you comment on that proportionality of penalty issue? Because I think it's a very important one.
You see, I come from a different perspective. I don't honestly see why, if you tell somebody not to do something and explain to them that it's a breach of somebody else's rights, and if they continue to do it, and you ask them again not to do it, and perhaps ask them even again not to do it, and they continue to do it, knowing that it is a breach of somebody else's rights, I don't see why it is a breach of their human rights to stop them using, even for a while, the medium upon which they're using to steal those rights.
Even though that medium applies to so many other daily activities?
Their medium is everywhere. I mean, if somebody gets cut off from one ISP, they can move to another ISP. There's an internet cafe down the road. It isn't, I'm not suggesting that they should be cut off from the internet forever, or that their entire household should be cut off from the internet forever.
Okay, thank you. Corey, do you want to come back on that briefly, and then I do want to go on to the other questions?
In Hadopi, it's not that you can sign, which is the French version of 3 strikes, it's not that you can sign up with another ISP. You're blacklisted nationwide. 92A, the New Zealand version of this, also had similar provisions. Some of the leaked drafts of ACTA that we saw when it was being negotiated made similar provisions. So I don't think that's true. And in an age of austerity, when libraries are shutting left, right, and center, it seems unlikely that the local library is the right place to get it. And of course, none of the statutes that we've seen for 3 strikes actually say when you have been asked repeatedly to stop doing something wrong that you've been proven to have done, you'll lose your internet access. Instead, what we see is when a rights holder claims, without having proven in a court of law that you've done something wrong, you and everybody you live with gets cut off from the internet. That's vastly different from someone who's convicted repeatedly of an offense loses a privilege.
Sure. Okay, lots more to pick up. I'm sure when we come back to the audience, we're going to ask Emin to react briefly, and then yes, if you want to add.
So, what can I say? I actually, agree with criticism. I take the criticism of our Russian colleague, and if he says that there is too much, focus on Azerbaijan. I just suggest that next time you take Russia and you invite, for example, Navalny here, and just to be more balanced.
Thank you. And yes, do you want?
I agree.
No?
I agree.
Okay, I just.
Absolutely.
I can't see where Robert is, but I know he's fielding questions from the internet. You're there, are you? Okay, could you give us one or two, and then we'll get the panel on the internet questions, and we'll take our brief coffee break.
I just want to check. There's comments and questions.
Okay.
So do you want them both? So
Give us a couple of comments, and then 2 comments, 2 questions. I think will be quite
so
enough.
A couple of comments going more for what was mentioned at the beginning. People were surprised online about the low percentage of number of human rights commissions that exist in the OSCE region. And one of the questions is what can be done to increase that from 64 to 80% or something more.
Okay.
There was an issue, there was a comment made earlier in regards to ICANN, the ITU, and others, and they're very different bodies that have different multi-stakeholder type of issues, and so some comment could be made to that. The other thing that was mentioned very recently, if people have longer statements or comments, could they be shared with the organizers or tweeted online so people could read them? So then I have some questions. And so each time we have a new technology, restrictions seem to be included. Why is that the case? So question for the panelists to answer. In regards to the presentation, there seems to be a divide between the panel. There seem to be panelists that are more focused on human rights, and there seem to be panelists related to intellectual property, 2 different silos. Are there issues where we can agree? And so it'd be interesting to see that. And should human rights protection, are they on the same level or different than intellectual property? So some comments in regards to that. There are 2 quick comments here.
Okay, make these the last 2, I think. It's a lot
so there
for
was,
now.
People online were contesting the view that about which type of industry was making money or not. So there were people quoting online in terms of that the music industry, in fact, was making more money than was being reported here. So that's any questions from that. And lastly, I'll finish here, is there's an issue in regards to a lot of different types of copyright bills that are being seen as censorship bills. And why are they being put forward when the public, particularly in many countries such as the US, Canada, and elsewhere, seem to be pushing back? So is there a disconnect between the public, the government, and the industry? And try to explain that. So that's it.
Okay, thank you very much. That's very helpful, and I think the helpful suggestion, I'm sure the organisers would be happy to respond in terms of longer statements being put online, can be passed to the organisers. I'm going to ask Michael to come back on what we can do to increase the number of national human rights institutions.
I was astonished myself when I did the sums. I didn't believe it was going to be so low in the OSCE region. Only 34 OSCE member states have a body that's in any way associated with the international regulatory framework for these bodies, the so-called Paris Principles International Coordinating Committee. And that's the figure I quoted. It should be way higher. What can we do? States have to take the initiative. National human rights institutions exist on the basis and thrive with the support of and encouragement of states. They're established normally under statute, but civil society has to agitate for them. And ultimately, a strong national human rights institution is one that will have the profound respect of both state and civil society. And that's as much as I could say today. But with regard then to a question about the 2 silos, which I think is actually a very good question. It raises an issue. I do worry that discourses can trot along in parallel without recognizing the points where they must engage. And some of the internet governance debate has trotted along as if there wasn't an existing human rights framework which binds states. And that's the hierarchy. States have freely committed to the international human rights framework through the whole panoply of the UN and the regional treaties. They bind them in every element of their actions, including everything they do with regard to regulation of the internet. And that's a simple matter of law, albeit it seems to be greatly overlooked in practice. What we do about that is we get states who are committed around these issues to remind their peers of the application of this normative framework, and we need civil society to get the messages to the courts, to the monitoring bodies, and to all the others, the high commissioners, you name it, who have a job of overseeing and bringing states to account to respect human rights.
Okay, thank you. And yes, could you maybe come in on this? Not the copyright issues, and especially I think that rather interesting question about the public as well as this sort of disagreement but on the panel between, you know, one writer, one publisher. But when the public get hold of a new technology, how important are they in starting to drive that political and legal debate about, well, what is the new model we're moving to?
Do I still have?
Yeah, you're still there.
Sorry. I think there are 2 or 3 questions in your questions. With regard to copyright, intellectual property and freedom of expression, I think it's an extremely complex issue, a very clearly conflictual and divisive one. It is a question of balancing rights. I don't think it has been done properly now so far. And with all due respect to the views you are holding very strongly, I do think that until very recently, until civil society actually got organized, the balance was clearly, heavily in favor of the side that you are representing. I think the process that has been followed around ACTA and other mechanisms similarly have done a great disservice to the rights that you are seeking to represent. They violated basic principle of fair process, of transparency. They've ignored major actors, not only civil societies, they've ignored national actors, India, Brazil, and so on. So I think maybe if we could, you know, step down, go back to square one and start again, that will be probably very good for all of us. Article 19 is engaged into that process. We're looking at how conceptually the 2 rights can be balanced in the same, using a little bit the same methodology we've used with the right to equality and the right to freedom of expression, which are also potentially often in conflict. I think there are ways of somehow finding a better balance, but as with all balances, there will be always people who, you know, will disagree with it. But maybe going back a little bit to square one will be a better thing.
Okay, can I stop you there, because we're a bit running into our coffee break. I mean, I think that's very helpful, because both Michael and Yes, in a way, have said, yeah, let's start to get out of these silos. Let's partly do that by going back to basics and saying, what do we want for authors? What do we want for us as citizens, not to be disconnected from the internet? But what do we do with a new technology that has all these different social and economic and regulatory ramifications is we may need that wider and better process of debate while we sort out what the new models may be. We're going to have a very short 10-minute break now. I know there's a number of you who've been very patient, so I think we'll start back and pick up 3 or 4 questions straight away. So if you can be back in the hall just after 3:45. Thank you.